Okay, thanks, Teresa. Look, people, what Teresa and Gil asked me to do, and Alex asked me to do, is to give you a talk on those topics that Teresa's just talked about. You know, what is Rule 41, and just generally an update on where things are moving in the mediation world internationally. Well, certainly as you know, where we work, which is Britain, Middle East, Americas, Australia, Far East. Well, yeah, pretty well everywhere, really. And so that's what I've done. So this isn't a dry analysis of the impact clause by clause of Rule 41. I'm going to touch on Rule 41 and to ask a couple of fairly big questions about it. And then I'm going to look at some of the other elements that I think are of relevance in answering how Rule 41 could actually become used and useful in the South African context. So Gil, if you can just move the slides on, because I'm not sure if I can do it from here. So move on once more. So I'm just go on one more, please, Gil. Yeah, there we go. So my job is that despite whatever the title says, I'm really the head of the RICS Dispute Resolution Service. And this has been running for 46 years. It's part of the RICS. The RICS is the world's largest built environment professional body. So we've got 17 professional groups in it, everything from QSs through to valuers, through to auctioneers, through to people in construction, the whole of the retail sector, estate agents. So everything in land, property and construction, 200,000 members and trainees around the world, offices in pretty well every country you can think about. And sitting within RICS is the Dispute Resolution Service, which has been running since 1976, so that makes us 45 years old. We make about 5,000 appointments a year of arbitrators, adjudicators, experts to do expert determination, mediators, dispute board members, and conflict avoidance panelists. We operate in 17 countries, 17 countries, 44 continents around the world, and we are by a very, very significant margin the world's oldest and largest built environment specialist dispute resolution and avoidance service provider. So, you know, what I'm giving you here today is perceptions of what might happen with Rule 41 in the context of what we're doing internationally and where we see mediation moving internationally. So if you want to go on once more, please, Gil, that would be good. Okay. So if people coming on to the way we work is that central to our cause, the RICS President's Panel of Arbitrators, that's about 650 people internationally, arbitrators, adjudicators, experts, conflict avoidance specialists, mediators, right the way across. They all sit on the President's Panel of Dispute Resolvers and Expert Witnesses. We train them up. They do the 18-month arbitration diploma, 18-month adjudication diploma, the standard 40-hour mediation training, which pretty well all training providers give internationally for mediation. And we then appoint them to the panels and we run them. So we've been running in South Africa, Alex, 10 years. And during that time, we've trained well over 200 mediators in South Africa, all of whom are sitting on the RICS register, all of whom have a specialism one way or the other in the built environment. They're either construction people, valuers, land surveyors, or they are solicitors or attorneys or advocates who have a speciality in the built environment in their practice. Okay, Philip, you can go on, please. So our approach is very different to institutions like CEDA or the Chartered Institute of Arbitrators, in that we are not primarily focused on training people to be arbitrators as such. We work, or adjudicators as such. Our starting point is that we take people with pre-existing skills and experience and expertise. So that strapline says it. We provide expert dispute resolution in the built environment by built environment experts. So taking it backwards, we tend to start with built environment professionals, be they surveyors, architects, engineers, whatever it might be, or lawyers with a specialism in land, property, or construction. Then we train them up and we give them the skills that they need to act as an arbitrator, mediator, adjudicator, whatever that might be. And they then bring with them the experience and the expertise that they will have gained typically in 20 years of practice or more, and they bring that with them to the dispute resolution arena in which they practice. So that's the proposition that RICS bases its dispute resolution on. Gil, if you'd mind going on. So, right, what does Rule 41A mean for mediation in South Africa? So let's have a look through. I'm assuming you've all read the rule and you're familiar with the text of it, because in 30 minutes I don't have time to take you through that. So shall we go on? So look, in essence, it's applicable to the High Court. And it encourages very, very strongly, and far more than we've ever seen in South Africa before, it encourages the use of mediation as a dispute resolution mechanism. And that is an extraordinary progress. I mean, we saw that court-annexed mediation effort that was made some years ago. I mean, the moment I clapped eyes on the legislation, it worried me, in that, to be quite honest, it looked like a recipe for, you know, people who are known to the clerks of the court, and who have little offices down the road, to become very cozy with the clerks and to get the mediation service taken to them, with all the possibilities for malpractice that's involved in that. It was only in the magistrates' court. I mean, if you remember, they trained up God knows how many hundred mediation clerks, or whatever they're going to call them. All of them within 6 months had left and gone and taken up traineeship in attorneys' firms around the country, more or less. It then landed back on the clerks of the court, who are incredibly busy and who don't have necessarily the skills. So the whole thing was a bit of a mess from start to finish. We as RICS got every single one of our 200 mediators registered on the government list. They all agreed to do it for nothing, as pro bono, and we as an appointing body heard absolutely nothing from anybody about it after that. So, it seems that it's not the field that we particularly practice in, which is built environment. It may well have been helpful in family and community and so on, but where we stand, we didn't see much happening. This change, though, by introducing mediation into the High Court, so long as the type of mediation service that is being offered to the public and to judges and to the legal profession is one that resonates with them, and is one which actually they would have confidence in, I think this stands a much better chance of making a real change to mediation and the acceptance and use of mediation in South Africa than what we've seen before. So in essence, rather like the pre-trial questionnaires that we've got in the UK, and which are common in many jurisdictions around the world, what the parties will now have to do is, right at the outset, when a matter is enrolled and when the summons and particulars of claim and when the plea comes in, they have got to file a separate document, as I understand the rule, which indicates that they have considered the use of mediation. Now, that business about showing that you've considered it is where the nub of the issue lies. There's any number of pieces of legislation around the world which place a responsibility or a requirement on the parties to demonstrate to the court that they have considered the use of mediation. And in many countries, all that has become is a tick box exercise. You fill in a tick on the form that says we've considered mediation, and you hand it into the court. And if the judges don't really believe in mediation, there's no particular emphasis or no particular pressure brought to bear on the parties to actually use it. And it simply becomes another form that you fill in, but in fact, you don't do any more than pay lip service to the idea. And if the South African judges don't buy into this, and if the South African legal profession doesn't buy into this, my fear is that it will go exactly the same way. And the only way they will buy into it is to have a vibrant, strong, robust mediation process available to the legal system in the High Court. And as far as we're talking at RICS in property, land, construction cases, which the courts and the attorneys would feel comfortable using and confident that it will give a proper result. So, and the last point, their failure to do so is inviting an exception from the other side. Well, clearly, if it is now part of the rules of court and it's not done. I was talking to Kevin Mullins, who practices at the Durban Bar, and he says he had a matter last week in which he had seen the papers came through to him from his solicitors, and he had seen that one of the parties had actually filed an exception to the particulars of claim because it was not accompanied by the necessary documents. So that's going to be an interesting wrinkle to see given that the document is not normally filed formally with the particulars of claim, it's going to be interesting to see what the courts rule on whether pleadings are excipiable if they're not accompanied by the Rule 41A piece of paper. So we'll, and yet watch this space. I mean, if the courts come down on saying that it's excipiable, that is going to really put pressure on the parties. But I think we're going to have to wait a little bit to see how the different courts deal with that, and it may well go through to the the Supreme Court of Appeals. But let's have a look to see how that's dealt with. All right, let's go on, please. So again, how does it work in practice? So it's compulsory to canvass mediation with the clients before litigation. I mean, that's really, really, really important because, but again, it ties in with what are you offering? So if you're an attorney, you're looking at going to litigation, you're looking at getting counsel to brief, or you're doing it yourself, you're looking at producing particulars of claim or a plea. Now it says that you must canvass mediation before litigation. How well are you going to canvass it? Are you really going to push the clients towards it? Or are you going to say, we've got to fill in this form that says we've considered mediation, but in my view, mediation's a waste of time. Do you want to say yes to it or no? And that's going to be where in attorneys' offices up and down South Africa, the conversations that are going to see Rule 41A used or not used actually being had. And again, I come back to the point that unless the attorneys are comfortable that we as the ADR community can offer a form of mediation which they can really buy into, this ain't going to go anywhere. The judges may direct parties to consider mediation at any stage in the proceedings up until judgment. Nothing really very much has changed on that. I mean, I can remember when I was in practice in Joburg in the 1990s, we had Edwin Cameron, we had a little spurt of judicial activism on mediation. And judges were doing that then. They were putting pressure on people to settle. So nothing particularly new, except that it's now embodied in a rule change. Obviously, it remains a voluntary process. The parties must agree to it. And yeah, this last point, we now don't have to have a little list with the Department of Justice, which really is yet another example of the government putting its fingers into what is, in general, a private sector process. So the fact that this is any mediator appointed through any mediation service providing organization can do this mediation is really important. And I think it's a crucial distinction. But again, what sort of mediation are we going to offer? Can you go on, please? Why? Well, I don't know why. I mean, the aim of the rule is to alleviate the civil trial load in the courts. I mean, before I started working for RICS, I was working for an outfit called the ADR Group in the UK. And I went over and spoke to the Rules Committee of the CPD. And that was in the mid-90s. No, late 90s. And they were then moaning about the civil trial load. So, I mean, seriously, nothing has changed. It has made big changes in Australia. The trouble with mediation in Australia is that it has become the almost exclusive preserve of the bar. So, I mean, in Sydney at the moment, and I was talking to people there last week about this, in Sydney and Brisbane, apart from the fact that they're all locked down under COVID, if you want a mediation, you're waiting about 6 months to get a barrister to come and do it for you. So, it has achieved a degree of success, let's put it this way, in Australia. Lowers the cost of dispute settlement and greater access to justice. Well, that's always open to debate, yeah. I mean, clearly, if it runs well, it lowers the cost. If it's rubbish, well, then it simply adds another layer of cost to the process, and you can see why attorneys are reluctant to engage with it. I mean, unlike going to arbitration, expert determination, or even adjudication, it doesn't provide a final decision. So, is it cost saving? If it works, yes, clearly. If it doesn't work, it simply adds a layer of cost and a degree of frustration and delay to the process. Justice more speedily served due to not having to await a trial date. Again, clearly, if you can get a settlement, you're not going to have to go to court. But if it's just, if it's badly run, it's not going to achieve that. All right, let's go on, Gil. Will it be used? I think this is what I've been referring to throughout. So it depends on the public, judicial, and legal perception of what is meant by mediation. It's not helped by court annex mediation experience in South Africa. Clearly that has, it's left people with a very high level of suspicion about what mediation is. I think mediation in South Africa has always been treated with a degree of suspicion. It's something that people are not familiar with. It's been used in what one might call the softer area of mediation, family, employment. People have had the experience of the CCMA, and they haven't liked that very much. Family, employment, community sort of areas. On the hard commercial side of it, especially where we function in the built environment, there's been a great deal of suspicion on it, which one needs to address really robustly if you're going to make it work. And again, quality of mediation available, individual mediators and service providers is really where it's going to be used. Phil, can you go on? So I've taken a quick canter through what the basic nature of Rule 41 is. I'm not going to go through it clause by clause. If you've got specific questions, I can answer them later. But in essence, it's a huge opportunity. But we've seen opportunities come and go, not only in South Africa, but in other countries around the world. And unless the mediation community really steps up to the mark and delivers a form of mediation which is accessible and acceptable to the legal community and the public, it ain't going to take us any further than we've got already. So what have we done at RICS to address this? And I'm not going to put us up on the sort of moral high ground of foresight on this one. We did it as a response. The changes that we made at RICS is a response to both the nature of the applications that have been coming into us for the last 10, 15 years and the experience of our panelists going out as mediators. So we work only in the built environment, and we have moved entirely from the facilitative form of mediation over to what we call an evaluative form of mediation. Although, don't get too excited about it, it is a very robust form of facilitative mediation, distinguished by the fact that the mediator is allowed, or indeed encouraged, to express an opinion on the strengths and weaknesses of the parties' cases based on their 20, 30 years of experience out there in the field. They are not giving a decision ever. They are not telling the parties what to do, but our experience uniformly has been that parties approaching us for the appointment of mediators are looking for mediators who have vast amounts of experience and expertise in the particular area in which the dispute resides, and they want the mediators to use that experience and expertise to assist them in understanding the strengths and weaknesses of their case, to the extent of expressing opinions on the strengths and weaknesses of what is being proposed in the closed sessions during the course of the mediation. And that is what we mean by evaluative mediation. When I did my training back in the 90s with ADR Group in the UK, we were told you never express an opinion. We weren't expected to be expert in the field in which the mediation took place, and we weren't expected to have read the papers in the dispute. All of that has changed over the last 15 years. Our mediators, in the form of mediation that we apply, need to understand the field so that they are speaking the same language as the parties. They need to be absolutely on top of the papers and on top of the dispute and properly prepared, and they need to go into it with a very robust approach in which they hear the parties, give the parties an opportunity to vent, give the parties an opportunity to express their views, go through in minute analytical detail, line by line, the strengths and weaknesses of the propositions that are being made and the options for settlement, do robust reality testing by facing the parties with the reality of what might happen if they took the matter onto court, or to most probably more commonly arbitration, and then assisting the parties on the strength of all of that to come to a sensible, commercial, forward-looking agreement which accommodates their commercial interests, their commercial relationships, and any plans that they might have moving forward. And that really is what we're talking about. So again, would you mind just moving on to the next slide? So, we've seen that the classic facilitative mediation used widely in labor and workplace, family, and so on, has become deeply criticized in the areas in which we work. It's seen as being very touchy-feely, non-specialist, underprepared, and insufficiently rigorous, all of which I've touched on in the last few remarks. Gil, again, could you move on? Just conscious of time. So, we've been through sort of a process. We didn't go straight from the facilitative model that we used to offer until about 10 years ago, straight into the evaluative. We sort of went through what we called acre mediation, which our people trademarked. Those of you who are old enough to remember pre-metric will remember that acre actually refers to a measurement of land. And it's the four, it's a sort of spin, so it's analytical. The analogy that I like is that if you look at countries like the United States, where they run civil trials in front of a jury, and you ask what is the function of an attorney, of counsel in a civil jury trial, your function is to analyze the facts, analyze the documents, analyze the law, analyze the arguments, in a way which equips and empowers the jury to make a proper decision in giving their verdict. In our form of mediation, evaluative mediation, we analyze the facts, the evidence, the documents, the propositions in order to empower the parties to make a proper commercial relationship. Commercial, remember that if you go to trial or to arbitration, the judge or the arbitrator can only deal with an issue that occurred sometime in the past, and look at the legal rights and wrongs about that particular issue. He or she cannot look at the current commercial relationships between the parties. It has nothing to do with it. Mediation is all about looking at the commercial relationships between the parties. And one must bear in mind that mediation is not a legal process. It's just a commercial process. It is a commercial negotiation which takes place very often within the shadow of ongoing legal proceedings. But it is a different animal. Whereas arbitration and adjudication is retrospective and has to look back, and litigation has to look back at resolving what happened 3, 4, 5 years ago, mediation is prospective, and it looks at setting up a relationship between the parties that they can work with moving forward. And it looks at much wider commercial issues as well. If the parties want to now go and build shopping centers in Zambia, that would have no bearing on a breach of contract claim in the courts, but it is everything to do with what the parties might look at now in mediation. So it's deeply commercial. Clearly, it's restorative in the hope that you will restore the trading relationships between the parties. And I've already touched on the fact that we use people who bring a great deal of expertise with them. So Gil, can you move on, please? Why have we moved across, and why am I thinking that Rule 41A would be well served in the land construction property area, commercial area, by this type of mediation in South Africa? We've seen the demand from applicants coming to us, applying for the appointment of mediators, who always want 20, 30 years experience and expertise and experience, understanding of NEC contracts, understanding of FIDIC contracts, understanding of JVCC contracts, whatever it might be, understanding of construction, valuation, quantity surveying, land surveying, mining surveying, marine surveying. The feedback that we had from our mediators saying that this is what they're being asked to do time and time and time again. And what we were doing is that we were training people up as facilitator mediators, and they were going out and acting as evaluative mediators. And clearly, as a Royal Charter organization who exists to serve the public interest, we were not serving the public interest by doing that. And we were creating an element of risk. So again, why we've changed, that's why. Gil, if you can move on. So what we understand by evaluative mediation, let's just whip through this very quickly because I don't want to spend all the time talking. If you can go again. So the elements of mediation remain the same. It remains voluntary, by which the parties to a dispute, rather than having they are assisted by a neutral third party. They are not told what to do. And it is fundamentally a commercial negotiation that leads to a settlement, which is embodied in a contract, which governs their interrelationship moving forward. Again, Gil, if you can move on. So nothing's changed. Litigation I've touched on, it's historical, mediation moves forward. Again, I've already touched on this. Gil, if you can move. All mediations are evaluated to some extent. I think those of you who are engaged in mediation will know that even in a facilitative or so-called facilitative mediation, you'll draw conclusions from reading the papers. You will evaluate which process to apply. You're going to meet them in private. You're going to meet them together. You'll decide what questions to ask. In deciding to ask a question now, not later, you are exercising a degree of evaluation because you're deciding, is this going to put them on the back foot? Is this going to encourage them to open up? Is this going to take me in the direction that I want this conversation to go in? When you are exploring options with people and you're developing options for settlement, even in the facilitative model, you are being evaluative. And whenever you do any reality testing, whether it's a BATNA and a WATNA, or you're asking people to imagine what might happen if the matter went to court or arbitration, it is impossible to do that without evaluating the strengths and weaknesses of the case in front of you. So, you know, we all evaluative when we mediate to some extent or other. This is just being a little more honest about it and encapsulating it in a set of rules, essentially, which provide a framework and protection that comes with having a framework for both the mediators and the parties. So, Gil, if you can move forward. It came out of the writings of Leonard Riskin in America, who produced what was known as the Leonard Riskin Grid, which looked at narrow, broad types of problems. So narrow problems, you've got the legal commercial problems. Broad, you've got family, labor, community type issues. We tend to work mainly on the narrow side. And on the y-axis going up, you move from facilitative behaviors through to evaluative behaviors. So if you go up the left-hand side, and facilitator mediation will ask the parties about the strengths and weaknesses of each side's case. Okay. They will ask about the likely outcome of court or other outcomes, will ask about consequences of not settling. Then you start to move sort of towards the cusp, will help the parties develop and exchange narrow position proposals. Well, once you start helping, you bringing your mind to bear, and will help the parties evaluate proposals as well. How do you do that unless you are using your critical faculties as well? Then you go across the line up into what he defined as evaluative activities. So you'll assess the strengths and weaknesses of the other side's case. So in other words, you're not asking the parties just to tell you what they think the strengths and weaknesses are. You're assessing them. But I challenge you, you would not know which strengths and weaknesses to focus on, even in the facilitator model, unless you'd evaluated in your own mind which the most important ones were. So, go around in circles. You would be predicting the outcome of court outcome rather than just asking them. You would be proposing agreements. All of that we don't have a problem with. He then said that mediators would also urge or push the parties to accept narrow position-based settlements. Now, we draw the line at that. We say that that is a determinative process rather than an evaluative process. Because the moment you start telling the parties what they should do, you step outside the role of being a mediator, and you become an expert, giving an expert determination. If you want us to appoint an expert determinator, we'll appoint one. If you want us to appoint an arbitrator, we'll appoint one. But if you want us to appoint a mediator, we're appointing something different. So to our way of thinking, and certainly in the approach that we adopt, that last highest behavior that Leonard Riskin included under what evaluative mediators do, we think that's wrong, and we don't accept that. So let's move on, please, Gil. So basically, we look at the golden rule, and this is drawing on Leonard Kwok, the Singapore judge who espoused the principle of self-determination for mediators. So you always, as an evaluative mediator, express an opinion to grow the parties' understanding of the issue and to increase the amount that they themselves engage their minds in considering the case. And by so doing, you empower them to settle. But what you never do is that you never express an opinion which has the effect of reducing the amount that the parties consider the matter, and by simply adopting your understanding and your reasoning rather than thinking it through themselves, because by doing so you disempower them. And that really is the fundamental principle which underpins the approach that we as RICS take to mediation. If you can move on again, please. So putting it in English, the golden rule is that you're acting evaluatively, not determinatively, and you're empowering the parties to make a sound decision. You're not telling them what to do. And that, in plain, ordinary Anglo-Saxon, is the basic distinction. You're empowering people for them to make a sound decision. You're not telling them what they should do. And that's really the fundamental issue. Okay, good. Let's move on. I'm just aware that it's 25-2. You chaps can have a look at these slides. You've all got them. They're pretty self-explanatory. I'm just aware where we are with time, so let's move through these greater ones.
That's no problem. We can go a little bit over.
Oh, you sure?
Yeah.
Okay, go back then. All right.
If you, we're at just quickly having a check, 10:38. But I mean, if you want to just take another 10 minutes for your presentation. So
no, in which case, let's go through then, please.
Yeah,
because
no problem.
Flip through.
Yeah.
Yeah, let's go down. 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 Okay, so all of those things, those slides that I've slipped through, that I've skipped through, I've more or less touched on those principles anyway in discussing. If you go back and you read them, you'll see that they simply explain what I've talked about. What I think is really quite exciting is to talk to you about where we have seen evaluative mediation being used in the UK, particularly, where we have moved. And if you ask me, where do I think dispute resolution is going internationally over the next 10 years? I think we're going to see a sea change away from those dispute resolution processes like arbitration, construction adjudication, expert determination, and even mediation, all of which are premised on the idea that you have a dispute that has happened. The dispute is then brought along to a dispute resolution process which resolves it. But by that point, the dispute is crystallized, people have taken sides, very often with mediation, and as Rule 41A implies, you will be dealing with a mediation that is already crystallized in ongoing established litigation. Right? Where it becomes very difficult for everyone to unpick it, be it an arbitrator, adjudicator, expert, or mediator. The move is to get in early, especially in construction, especially on big infrastructure projects, to bring in about a conflict avoidance process, which, in a sense, stamps out the smoking grass before it turns into a bush, into a felt fire. And we have done a huge amount of work with, we started off with Transport for London, and it has now grown very, very considerably over the last 5 years, in which we wrote into the NEC contracts that Transport for London, which runs the underground tube, the tube service. So 4 years ago, NEC, the EU Directive on Collaborative Contracting came out and became part of British domestic law. And what that said was that any publicly funded organization had to enter into a process of collaborative contracting, conflict avoidance with their key contract delivery partners, which is a posh name for contractors. So Transport for London was at that point rolling out £7 billion worth of contracts to extend the underground, refurbish some of the stations, and to do the escalator links across to Crossrail. And it was working with Costain, Laing O'Rourke, Taylor Woodrow, BAM, and Skanska. So we worked with them to establish what's known as a conflict avoidance panel process, which means that if any of those parties identify an issue which is starting to bubble under and which has the potential to actually go to adjudication or to arbitration or to litigation, they then approach us, and we then appoint a conflict avoidance panel, which is either a one-man or a three-man panel, which then meets with the parties, visits site, and tries to find a sensible commercial settlement to prevent the party growing to the point that it goes on to arbitration, adjudication, or court. And central to this thinking is that the issue is dealt with when it still sits in the hands of the project delivery team before it gets handed over to the internal lawyers, because they have two different mindsets. The project delivery teams on both sides want to get the project done. The lawyers want to start protecting the clients against further admissions or further actions that might incur further liability. And it's that difference in mindset that is so important to this whole sea change towards earlier intervention. So why is this relevant to mediation? Because what the conflict avoidance panel do is effectively a two-stage process. They meet with the parties, they discuss with the parties, they use all the techniques of evaluative mediation to try and resolve the matter early. What that certainly always does is narrows the issues, and what there may well then be a final point, which is now clearly defined, upon which the conflict avoidance party produces a fully reasoned written recommendation within 28 days, which draws on adjudication legislation, which doesn't bind the parties, but which is highly persuasive. So we've done 40-odd cases for TfL in the last 4 years. £400 million worth of disputes have been kept out of the courts. And so far, touch wood, every single one of those recommendations has either been accepted as it stands or has formed the basis for a limited amount of further negotiation, which has led to a settlement. So far, an enormously useful process. Urban Growth Company, the second one, is running the biggest rural redevelopment scheme. So it's Birmingham International Airport. It's going to have the HS2 station on it, the rail station, the airport, and the National Exhibition Centre, and 500 residential houses. Huge scheme. They have now made the RICS cap process that I've described to you a prerequisite for all tendering contractors in order to qualify. So an enormous step forward. We're also working with various government departments, the Welsh Assembly, Northern Ireland, the Scottish National Health Service has now accepted the RICS cap, and we're dealing with, we've just appointed a cap on a hospital up there that hasn't been built well, and Network Rail has grown into it as well. So we've done a huge amount of work, and in the middle of all of it is people who are trained as evaluative mediators, who bring with them a vast amount of specialization. So this isn't mediation, but this is mediation embodied in the very heart of probably our most exciting development in the last 20 years. Let's move on one. And clearly, I mean, in South Africa, that is We were nominated for the British Construction Industry Awards last year for this work. And that is a slide produced by Transport for London, which shows the effect on their disputes of the introduction of our service in 2016. So the disputed events in red are the ones that actually went to adjudication, or litigation or arbitration, but primarily in the UK adjudication. The green ones are the agreed events, which would have settled anyway, but only after a vast input of time and energy and management time. And you can see the introduction of the conflict avoidance process was absolutely phenomenal. Let's move on again. You're going to have to click your button a number of times to bring the things up. There we go. Yeah. So we've created the Conflict Avoidance Coalition with major other delivery partners, the International Chambers of Commerce, Institute of Civil Engineers, Chartered Institute of Arbitrators, Dispute Resolution Board, and REBA. And we've created a coalition we're talking to government, we're talking to institutions, we're talking to the industry to introduce conflict avoidance processes, all of which involve an element of evaluative mediation. If you'll go on, please. We brought out what's known as the Conflict Avoidance Pledge, which is a pledge which major, and right the way down, major institutions, contracting companies, subcontractors, individuals can sign up to, which say that they will make sure their boards and their staff are familiar with conflict avoidance. They write the clauses into their contracts, and they will use the processes. Well over 250 major companies have signed up to it now. Heathrow Airport signed up a little while ago. Going down one more. Some of the people that are on there, you'll recognize those names. We need to take Carillion off, seeing that they've gone under. But we're not talking about fly-by-night organizations here. And if you can go once more, that's it. Okay. So, I've come out of quarter two, so that gives us some time for questions, and if anybody's got any.
Yeah, so first of all, John, thanks. I think that was two topics for the price of one. I have to say, I think both of them were very interesting. I think we agree on both of them. Especially the evaluative mediation is something we run in the Netherlands a lot, where we see that we're one of the few bodies that does kind of promote it. But we do see the potential as well, so that, shake hands on that. We have some questions. The first one, if the presentation, so the slides will be forwarded, they will. So there'll be a link that we'll send you when we send you the presentation in the YouTube video. In the description, the link will be there. So you'll be able to just download them and go through them, like John said. John, we have a question for you.
Chris, what happened with the RICS panelists in South Africa and Sub-Saharan Africa to promote its mediators, arbitrators, and adjudicators?
Yeah.
Chris, there's been a huge amount of change of staff in South Africa, as you know. Yasmin Najwati is now in charge of it. It's being picked up again quite hard. I think, given that this is a wide panel, possibly talking about internal RICS matters, we'll take that one offline, I think.
Yeah. No problem. You can just reach out to John. I'm sure he knows your contact details, and then do it in private. If anyone else has any other questions, either about RICS or evaluative mediation, or obviously Rule 41A, feel free. I think one of the things I wanted to ask you, John, is I mean, obviously the Australia experience you mentioned, where they had a bit more success. They also had a lot more work done at the contract side, where they have things like you have to have I think they refer to it as a genuine attempt at mediation. And there are some requirements that you have to try there. So I'm not sure how effective that was, but I mean, what we see in South Africa, at least the risk where it has developing, is that if there isn't a system around it, it's really going to be up to individual mediators to go out and reach out to judges and to law firms to actually make their case.
Yeah. I think you're right. I mean, to my mind, I think Rule 41A, the change is hugely welcome. It once again focuses people's minds on mediation and the importance of mediation. But ultimately, it's going to work if there is something there that people can use that they have confidence in. And the way it works, there's nothing wrong with the fact that attorneys have got a little black book with the name of mediators that they like, and they go to those mediators and they appoint them. They don't need service providers and third-party bodies to appoint mediators to them. And, for many years, many attorneys have been doing it extremely well.
Well, look, we see a system.
It becomes,
John?
You see the system?
Oh,
the top of you here?
Yeah. I was just seeing your video cut out. I think it's worth if you just turn it
system's
off
breaking down a bit.
if you just turn it off for
Yeah,
a second, and then I'll just turn mine off as
I
well.
can't hear you.
Ooh. Teresa, can you hear
Yeah,
me?
you cut out. Yeah. No.
It's
Yeah.
back.
I think it's back. Yeah.
Okay. Yeah. So I mean, that's one of the things, like you said, with not having a black book. I mean, we see that Italy is a good example in Europe of a system where they've gone a completely different direction, and they've embedded some systems of mandatory-ish mediation, but then you still see courts or attorneys being able to choose their mediator, and there's nothing necessarily wrong with that, so that you will still have that list. And so I think one of the advices we can give your members and our members, if they want to make this work, is actually reach out to law firms. I'm not sure if you agree with that.
If you're setting yourself up as a mediator in private practice, the first thing you do is that you use every contact you've got with lawyers, because they are the gateway to mediation.
Yeah.
Signing yourself up with a service provider is useful if you come from if the service provider has particular reach into a particular sector. Yeah. It makes sense. If you have got people applying to a service provider who want mediators who have particular skills in particular sectors, know certain contracts backwards and forwards, know certain profession, they know engineering, or they know land surveying, or they know medical malpractice, or they know whatever it might be, and your service provider specializes in that and has a mechanism by which they can look at the nature of the dispute and say, yes, we've got just the right person for you, who has got the experience and the skills and the geographic understanding and whatever it might be, then yes, it all makes sense to register with a service provider. But otherwise, you don't need to as a mediator. And if you really want to get your practice off the ground, go and
exactly.
Cozy up to as many solicitors as you can, or attorneys as you can.
The onus is really on you, and that's one of the questions we've had. It's not like this rule will automatically generate work. It's a tool that you now really have to wield effectively.
I mean, you cannot expect a service provider to keep you in business. It's not going to happen.
Yeah,
what they will do is they will send you appointments if and when the applications come in, which are relevant.
I mean, the only exception to that rule would probably be if the service provider would be the government. I mean, you see that in Italy, where they have 200,000 mediation cases a year. That keeps many I mean, that obviously then it's a whole different animal.
Depends.
But in private market situations, it's unlikely.
Yeah, it depends. Yeah, I mean, there are some countries where you've got government mediators, and then you start running into all sorts of questions of funding, quality. How good are those mediators? There's all those sort of issues then.
It's not that it's government funded. It's just that it's government. It's just they have an accreditation system, but then it's also mandatory. So there's 200,000 mediations being done by private mediators, but on a government list. I think that was kind of the exception. But I want to get to the questions, otherwise we're taking time. We have a question from Aisha Shabil.
Do you find the need to ensure the mediation agreements are court orders? Is this stick required, or do parties adhere regardless? Our experience in the UK, Australia, Middle East has been that parties tend, Aisha, to adhere to mediation agreement without it necessarily being made a court order. However, where mediations take place in the context of ongoing court, which is the only place that you can make them court orders, and it's easy enough just to go and get a consent order. Parties very often do. The difficulty with that is that mediations obviously are entered into because they are confidential, and the outcome of the mediation is also very, very confidential, and very often in commercial matters subjected to non-disclosure clauses. The moment you go and you file those papers in the court, in the registrar's office, they become public documents. And so the confidentiality is breached. There are ways around it. There are orders that you can take in the UK by which the mediation settlement agreement it's called a Tomlin order, because that's the first case in which it was dealt with, in which the order is that the mediation settlement agreement will be kept by the solicitors rather than being kept in the registry, court registry, and will remain confidential and will only be brought back to court if in the event of an alleged breach. So a Tomlin order is a way of getting around that, but I'm not aware of jurisdictions outside of the UK in which Tomlin orders are used regularly. Okay. So I don't know if that gives you some sort of answer to it.
Yeah, she says it's answered. The next
Okay.
one from Conrad Bromley.
Okay. In
Not
a
sure if you read it.
COVID-impacted, in a COVID-impacted world, is there an opportunity for mediators in South Africa that are based elsewhere in the world? The Middle East, for example, to what extent is remote mediation likely to form a part of the process? It depends on how complex the issue is and how specialized the issue is. My sense is that South Africans will probably look first to South African mediators, just as Australians tend to want Australian mediators and so on and so forth, unless you're talking about a highly complex engineering issue or question about a FIDIC contract or an NEC contract, in which case what they're really wanting is particular expertise, and in which case somebody coming from somewhere else in the world would work. And absolutely, rather than having to put that person onto a plane and fly them there, we would now just do it by way of the same platform that we're using here or another platform. So yes, I think the greater acceptance of remote working and IT platforms has opened all sorts of doors in mediation, but I think there will still be a local bias, if one wants to put it this, or a local preference will still continue, I think, for most media.
Is this something you guys have experience in with online mediation, or is it mostly
We're doing all our
on
mediation
location?
online now.
Online,
Yeah.
okay, all of
Yeah.
it. Okay.
But I mean, online, everybody says as if it's something terribly exciting. I mean, we always had all the papers sent in by email, and the preliminary, things took place by web conference calls. So it's no big deal. I mean, instead of people getting together somewhere, now they just sit and do it as we're doing it now.
Oh, I agree with you, but the thing is, there are some circles, and that's, I think, obviously why we at least why I wanted to ask the confirming question, where, like with you mentioned with the values mediation, where it is a bit looked down on as a kind of I don't want to call it a sin, but it's just seen as something quite alien or scary to people, and they're not convinced it works yet, and so it is new to a group of people. We see that
new
in
to many people.
And so.
So why would an attorney give
Oh,
work away to a mediator when they do not have enough work? Okay, well, here's the point. The figures that we have in the UK, and I mean they were certainly like this in South Africa, is that of the cases going to the Technology and Construction Court, 93 point something other cases settle. They never go to trial. And those are the cases in which papers have actually been issued, pleadings have been issued. If you were to take the percentage of all disputes between parties which are sent to attorneys, the vast majority of them never ever see the inside of a court. So when one talks about mediation as being an alternate to going to court, that's actually wrong, because most cases are never ever ever going to go to court. What mediation is an alternative to other less satisfactory ways of settling matters. So I can remember time and time again being briefed, appearing at first day, taking my first day fee quite happily, but knowing full well that the matter was never going to run. And I can remember standing in the back corridors in Pritchard Street in the High Court with my opposite number scribbling down the settlement on the back of a fag packet. Now that's no way to settle a matter. What the type of mediation that we're talking about offers is an opportunity for the parties to meet with someone who really understands the field, who sits down with them, goes through line by line, item by item, the proposals that are being made, and the strengths and weaknesses of 4 or 5 different options. So, are you going to amend the contract? Are you going to give them a franchise? Are you going to simply walk away? Are you going to enter into a new contract? What are you going to do? And you look at each one of those options and say, what would the impact be on your business line, on your public confidence, on your reputation, on your ability to work within the market with these people again in the future? And you take it all through a system of very robust, careful analysis, looking at future plans, looking at commercial issues as well. And at the end of that, coming up with a really important commercial settlement. Now, that is what you're buying into as an attorney when you do a proper mediation. And you are going to have to prepare another set of documents. You're going to have to consult on that. You might have to represent the parties at the mediation. You're going to have to prepare a mediation bundle. You're going to have to index and paginate it. You will have to do all of those preliminary processes, all of which you charge fees for. So, from an attorney's perspective, you're not really giving the work away any more than you're giving a work away to a judge. What you're doing is that you're using a different mechanism to get a much better result than if you'd simply paid to go to court, paid counsel to appear for 10 minutes, but charged for the day to go and scribble down an agreement that you'd more or less reached anyway. So that's actually why it makes sense.
I mean,
If the process of mediation is a solid, robust one.
I mean, Frans, the one thing I'll add, I'm not sure if you are an attorney, but in the case not, what we see often is when we do pollings around attorneys, we don't do them, but other organizations do that for us. We often see that they are quite willing to go to mediation, except they might not understand how it works, so they might not understand where to find one, and so there are more logistic issues rather than fundamental and principal issues that prevent them from referring it through to mediation. I mean, in the Italian example, where it's mandatory, they were opposed to it at first, into the introduction of that law, but afterwards, I mean, opinion polls around in that field, they show quite happily that the attorneys are quite happy with that procedure because it didn't necessarily lose them a lot of work. It's just like John said, it's different work, and so I'm not sure how valid that is in practice. I think it's more when you actually ask the attorneys that they are facing different problems rather than just giving away work.
Yeah, it's a vexed one. This, I mean, for many years, ADR has been seen as alarming drop in revenue by solicitors, but the reality is we're not finding it that way. We're seeing many solicitors see it as an alternative means of generating revenue.
Yeah, no, that's what I was saying. The polls, when you actually do the surveys among them, they kind of reflect that as well. And then when they run into problems, it's more logistical. What is mediation? How do I find it?
Correct.
Or it's not suitable for the specific case. So those are different issues.
But again, I go back to the point that this Rule 41A thing is only going to work if there is a form of mediation available, readily available, and easily accessible to solicitors and parties in South Africa. Otherwise, it will be the same as any other thing. From Reg Reynolds, evaluative mediation, as you describe it, appears to be essentially what FIDIC 2017 envisages with the Dispute Avoidance and Adjudication Board. Yeah, of course. I mean, it forms part of that process. I mean, all of these things are related. The distinction between I think evaluative mediation is the fundamental process that is common to dispute boards, DABs, DRBs, conflict avoidance panels, all of those forms of intervention. Where the conflict avoidance process that we are talking about in the UK differs from the dispute board is that it's an ad hoc. So as the dispute arises, we appoint the person with the skills or the people with the skills that are needed for that particular dispute. Whereas with the dispute board, what you tend to have is 3 people appointed for the duration of what could be a 10-year, 15-year infrastructure project. And, you might have an engineer, a surveyor, and an attorney or a solicitor appointed on the dispute board. And our experience is that with the best will in the world, the skills and knowledge set of those 3 people will never be wide enough to cover every single type of dispute that would arise. And I mean, if you look at Transport for London, you've got electrical disputes, transport disputes, logistical disputes, construction disputes, mining disputes, tunneling disputes, land, soil chemistry disputes. I mean, you name it. There's no way that 3 people are within their 3 heads going to have all the expertise that they need. So what you tend to find is that the standing dispute boards very quickly have to start relying on experts. And that almost in a sense undermines the purpose of why they're there. So the process that we're talking about addresses that by matching the dispute resolvers in the form of the conflict avoidance panel far more accurately to the nature of the dispute as it arises. Okay, Chris, my personal opinion is that South Africa is rife with conflict and there's a great demand for conflict management and dispute resolution at all levels. Yep, I agree. In the near future, adjudication and construction. Well, let's hope so. I mean, I don't know if the legislation's ever going to see the light of day, Chris, but hopefully contractual adjudication will happen. And as you know, we're running the adjudication diploma in South Africa at the moment, and it's going quite well, I think.
Good. Next one from Alfred.
Alfred. The following question may not be worded as well as it could be, but in consideration, I'm posing it. Hope that is just what I'm trying to ask. In your opinion, is it better to have a respected, qualified, experienced legal professional who's versed in mediation, or an experienced, highly trained professional mediator with many years of experience, so vast general knowledge and experience in law and mediation assessing parties? It's a barbed question, and I'm not going to just fall into answering it in generality, because very often the success of mediation depends on the skill of the mediator. And whether that mediator is coming from someone who is a lawyer or somebody who's come in from the sector and come in, to my mind, I don't think it really matters, so long as they have the skills that they need at the end of the day. We
Well,
as an institution, obviously, as RICS, we have 200,000 surveyors at our disposal. So the vast bulk of our mediators tend to come from the construction or the land or the property professions, and they assume the skills of being a mediator, arbitrator, or an adjudicator. But at the end of the day, it's only going to work if the individual who runs it has both the sector knowledge to make sense of the dispute that the parties are talking about and the dispute resolution skills in the discipline of mediation to actually provide a good service. Okay.
yeah, I mean, one of the things that you mentioned as well is that it's perhaps also important that or at least parties value the fact that they have specialist knowledge rather than that they come from one or another background. And so, Alfred, I think it's also important to note that these two situations aren't mutually exclusive. And from our side, we haven't necessarily noticed any difference between who registers. It's like John said, it's about what you know. That's and specifically how you apply that to whatever process you're going through. Okay. If anyone else has any other questions, go into the chat or in the Q&A box. Feel free to ask them. We have another one, John.
Your thoughts on lawyers mediating without the necessary mediation training? The trouble is, I got thrown into mediation when I was at the bar without any mediation training at all. And it was only in retrospect that I realized that what I'd been doing was mediation. But I think in general, anybody setting off to become a mediator without having at least a 40-hour training which sets out what the fundamentals of the process is, you are looking for trouble. All of us in the caring professions, lawyers, surveyors, engineers, and the like, we are paid to tell people what to do. As counsel, you sit in your chambers and you approach to give an opinion. As a solicitor, people come into you looking for advice. As an engineer, you give advice all the time. As a construction person, you tell people what to do as a QS. We are steeped in this idea of helping people by solving their problems for them. That's not what mediation is. Mediation is a process where the people solve their own problems with your assistance. You express your views, you use your expertise to empower them to reach a decision. And if you don't understand that, you run the risk of simply overwhelming them, especially if you're a lawyer. And they come along to you and they think, oh, well, you're a lawyer, therefore you must know everything, which is an unfortunate connection that people make, which bears no connection to reality. But they do come along and they do listen and they do take your advice. That's not what mediation is all about. If you want to go and give expert determinations and you want to arbitrate, go and arbitrate or be an expert determinator. If you want to be a mediator, then you need to understand what the process is all about. And I think the answer to your question is, my thoughts on lawyers mediating without the necessary mediation training is that I dare say there are many of them who can do it. I think I did it, and I did it reasonably successfully, but I do wish I'd known what I was doing before I ventured out into it. And I think, having I was brought up on a farm in the Eastern Cape, and I remember watching my father perform operations on animals. In those days, in the 1960s, you didn't get a vet in. You got a light in, you connected it to a generator, you took a knife and you opened them up, you took it out and you sewed up the cow, the sheep, and you sorted it out. Now, Dad did it fine. I've done similar things on animals over the years, in the farm, but it would have been good to have just a little bit of training to know how you put sutures in, how you do this, how you use a scalpel properly. And I'm sure had he ever had the opportunity, Dad would have been like a shot to go and get that additional training to provide him with the skills for what he was doing. He did it fine, but I'm sure he would have benefited by understanding what he was doing in advance. Okay.
Sorry if I can jump in here as well.
Yeah, Teresa.
We've got quite a few lawyers and advocates attending today. And what we're finding on our side, on ADR Register, is that I would say the majority of them on this session today have actually done or are in the process of doing mediation courses, because
Yeah.
they're starting to realize that they don't have all the skills. And it's quite nice to see that people are open to learning new skills, although, as you say, you know, in the legal profession, you sort of do believe that you know most of it. But so we're finding that people are very open to doing the courses and getting the accreditation or the certification for that, which is great.
Yeah.
Yep.
Yeah. I don't think I need to egg it any more than that. I mean, we've got very good lawyers on the panel, but I've also seen the most appalling mediations being done by lawyers who believe that they are mediating. Meantime, they're not. They're just telling the parties what to do.
Yeah.
And then they're really surprised that they get absolutely nowhere by the end of it, because the parties are still as entrenched at the end of the session as they were at the beginning. So, you know, I never think it doesn't ever hurt to acquire the skills that will advise what you're doing. You didn't go and become a lawyer without going to law school.
No, definitely.
No.
We have one comment. It's not necessarily a question from Aisha Sabil. I'm not sure if you want to comment anything on that.
I agree that mediation empowers. It actualizes Section 10, the right to dignity. Yeah, that's a very good point. Can't improve on that.
Yeah. So for now, unless anyone has any last second questions, we'll just get through them as well. If there's anything you want to know, you can always send an email to John. His email was in the presentation. Like I said, we recorded this webinar. We'll send the link out either at the end of this week or early next week, including with the slides. So you can go and download them and go through the ones that John mentioned. You can read through that we skipped over in the interest of time. From my side, I want to say thank you, especially also to you, John, for lending your time. I thought it was quite interesting. I hope it was useful for everyone. Yeah, I want to close it there. Teresa, anything to add?
Yeah. Thanks so much, John. We really appreciate it, and we'll stay in contact.
Oh, good.
Definitely.
Lovely.
All
Okay,
right.
everybody.
Bye-bye.
Thank you then.
Thank you. Have a nice day.
You too. All right. Bye-bye.
Bye.